This episode of Pharma Faceoff is brought to you by
Can states prevent pharmacies from selling prescription data? Is it infringement of pharma reps' free speech or a protection of physician privacy? Before the Supreme Court weighs in, we will. What was the interest that states like Vermont are trying to protect for doctors?
One of the problems that a lot of states and their physicians have been encountering in recent years has been rising drug costs. And there's also been a lot of concern about privacy, both physician privacy, patient privacy, sort of runaway data outside. And so bringing those two concerns together, what Vermont was really concerned about was they wanted to try to slightly influence the way that pharmaceutical detailers interacted with physicians.
Jody, this is obviously an issue that hits very close to home for SDI. What is at stake here?
What laws like Vermont's and other laws like it do effectively censor the type of information that we can provide. This is truthful, factual information. Courts have ruled that data even devoid of expression are entitled to free speech protection, and so we're very concerned that laws like this essentially allow the government to take a form of censorship and legitimize it.
One of the questions I have that's very unclear, I mean, prescriptions, they are required by the state, they're written by a doctor, they're given to a pharmacy. They're very complex things. Whose data is it?
Pharmacies own this data. Right, so we have a pharmacy, it gets a list of, say, the number of prescriptions and the type of prescriptions from a doctor. It then can strip out the patient's name and identifying information, but then it does assign a number to that prescription so that it can always follow, say, what that particular entity, that person, what drugs they're receiving. So they do have these lists, but there are very important interests of both physicians and patients in each of these areas. And I think that one of the interests is that patients can worry, for example, what happens if these pharmacy records get in the wrong hands.
You raise interesting points, but I think there are some misconceptions about how the information is used. We're the only ones in possession of the record, and so it's not freely available for others to try and re-identify a patient. But furthermore, HIPAA has a very important clause in it that is that it doesn't have a doctor component to it. And what the laws have attempted to do is define a right of privacy that simply doesn't exist. Now, I understand the perspective of the sensitivity of some of this information, but in terms of what we're trying to accomplish, we are not producing any information that is otherwise illegal to produce by virtue of HIPAA, nor are we infringing upon any rules that have the doctor's information otherwise blanked out.
I do think those are very important points about the federal law. However, I think that one of the things that I heard among the Supreme Court justices as they were talking about this case was a very simple, narrow view of privacy. Okay, so they tended to think of privacy, and you heard this repeatedly from Justice Scalia in particular, as if you want privacy from pharmaceutical detailers, slam the door in their face. And it was kind of funny to hear from the one justice who was most sympathetic, I thought, with the pharmaceutical company's point of view, that he kept saying, if doctors want privacy, just push the detailers out of your office. And even the advocate for the data companies and pharma, Tom Goldstein, said, yeah, my father's a doctor, he doesn't talk to these detailers. So what I think is interesting here is that if you want to have an all or nothing sort of scorched earth litigation tactic that says, we're going to have complete access to everything, you're going to really risk a backlash from physicians. And I see this as a very modulated, moderate approach to the problem of pharmaceutical detailing. We're saying, no, we're not going to slam the door in everyone's face. We're just going to say, when you interact with us, we don't want you to have this type of very specific data.
One of the misconceptions here is this is a widespread concern on the part of physicians. There's an existing proxy in place for that physicians have redress in the 47 states that have not enacted similar type of legislation called the AMA Prescription Drug Restriction Program. It's available to all doctors, not just members of the AMA. And when you look at the statistics, you would think that if it was a real interesting type of program, ones that doctors zealously wanted to be a part of, 50%, 75% would have signed up for it. The current statistics as of last week, and this program's been out there for 4 years, and it's been advertised in over 70 medical journals, the statistics suggest that it's not really an interest for the doctors, and they understand that. 2.6% of physicians have signed up for such protection, and in Vermont, it's less than 2%. So even in the state where there's a concern, the doctors aren't really interested, and so that's one of the reasons why we're pretty concerned about a very small but vocal minority speaking on behalf of the data interest.
Yes, the number of people signing up is low. I've heard 2.6%, 4%. Yeah, it doesn't seem like doctors are affirmatively opting in that aggressively. However, I think that we also see there are certain parts of our life where we might say to ourselves, hey, we want to pre-commit ourselves as a group to sort of taking a progressive action going forward. And in Vermont, all this is the difference is opt-in or opt-out. If physicians want to be part of the program, they can opt in. Vermont is just changing the defaults.
And obviously the default is what we consider a concern, because by essentially restricting the speech point blank, you're not giving the doctors who may be in the middle of this issue an opportunity to have their information used by default, and they may desire to have that done. The law does permit for academic research and formulary compliance, essentially all of the reasons the government would think is good for this information to use. What it does is it discriminates on one view, which is the marketing commercial use of the information is considered not so good. So we're not going to allow that to be used. I think our concern is with the default position, certainly being in the off position, but in general, I think to create a flow of information, transparency in the marketplace, all parties should be able to monitor other parties. All we're doing is we're publishing information. We shouldn't have to put black boxes over our data cells.
You raised an interesting point with kind of this discussion of free speech, and in a lot of ways this debate has really been framed around free speech. The reps can still go and they can visit a doctor, they can still talk about the things they're doing. How is this fundamentally a free speech issue in that they're still given the opportunity to talk about the same things, they're just not going in with the same data set that they would otherwise?
And actually you just stated it. Effectively, the law makes it harder, makes it less efficient. The most efficient form of communication is for a pharmaceutical company to understand who they're going to speak to and be able to communicate and educate them using an appropriate message.
There are some legitimate concerns here about, say, the free flow of ideas and the free flow of information. But I think we've also recognized over time that the government does have a right to shape certain forms of information transactions and information flows to make for a better overall information environment.
I'm kind of curious, Jody, if you can tell me a little bit about what you think the implications would be should the court decide to uphold the law.
Well, should the court decide to uphold the law, I think there's going to be a lot of concern on the part of people, publishers in general. This is a law that, once again, suggests that there's something that the government doesn't like, and in order to create redress for this problem, they're willing to restrict speech if they can construct what they consider a compelling reason, which obviously we debate. Other publishers would have similar types of concerns. What type of information, just because the government doesn't like what it's used for? If it's published, if I don't like certain stock prices or baseball scores, I can just put a black box over it, and it's just information, it's data, and data forms the points of ideas that all of us have. And so we support it. We support our concepts and our thoughts on the basis of data in a lot of cases. Restricting that information restricts truly the types of ideas we have. I'm very concerned that should these laws continue to proliferate, that ideas will be restricted, that this marketplace of ideas will in fact shrivel.
I don't think that the concern is that great. I mean, I'm reminded of sort of the great database protection debate, where in the EU there is sort of intellectual property protection for databases. There's not so much in the United States. There were lots of predictions that the sky would be falling among those who operated databases in the U.S. when we didn't protect them. It didn't happen. We still have a very robust database industry. I think the database industry is going to do well regardless of how this comes out. However, I do expect the Supreme Court to come down on the side of the data miners in pharma, just given the oral arguments and the ascendancy of commercial speech interests in this court. Now, the way they do it is very important. I foresee two possibilities. One being a sweeping sort of 5-4 decision, where just as they did in Citizens United, you see a court that sort of reaches out and tries to make a broad statement about the relative balance between First Amendment and privacy interests. I'm very worried about that because I think it could sweep away far more than this law. I think the wiser course, if they do decide to overrule or to invalidate this law, would be to go for a narrow reading that essentially would attribute the decision or the opinion to suspect motives on behalf of the Vermont legislator and its legislative findings.
One of the other questions I had, and I'm curious whether either of you have some thoughts on this, is Vermont recently passed a universal health care bill. It's probably the closest thing to a single-payer system in the U.S. And do you see this kind of legislation as related to that, as kind of part of a larger effort, or are these two things kind of separate?
I think that's a terrific question, Reed, and I think that there are actually deep structural parallels between the reception of the Affordable Care Act after the National Health Reform Act, after it got passed, and what's happening in Vermont. And here's the parallel I would draw. I think that the Affordable Care Act is a very sensitive balancing of interests of industry stakeholders and the public interest. And I remember there's an anecdote where someone said, you want a government takeover of healthcare, that's a 2-sentence bill. Everyone's in Medicare, it starts tomorrow. Okay? The Affordable Care Act is a 2,000-page effort to balance the interests of all these parties, but it's still under constant attack and under constant constitutional attack. And we may well see it unraveled on a constitutional matter. This, by the same token, what Vermont had tried to do was, I believe, a very sensitive balancing of industry interests with public interest. And we see it under constitutional attack. And I think that what you're going to see in the future is, if there is more of these types of litigation tactics to get rid of moderate type of legislation, you'll see happening exactly what Justice Scalia predicted, a cultural shift where doctors slam the door in the face of pharmaceutical detailers because their efforts to level the playing field informationally have been thwarted in the courts.
Laws like Vermont's Universal Health Care Bill really mark the times that we have, where a lot of the argument for the Vermont bill, which is the data bill, was rooted in the fact that we're trying to make things less costly for individuals. But the fact is that if you look at the macro level trend, we have more access to health care than we've ever had. Now, there still are issues, but prior to 2006, seniors did not have any benefit that was prescription-oriented related to Medicare. Healthcare reform provides access to another, depending on what number you believe, 15 to 30 million, and the Vermont Universal Health Care Bill will provide similar type of access. That type of access pool is good for patients, and so there's going to be more patients who have access to medications who going forward didn't previously have those access to the same medications, and I think that's a good thing. And whereas restricting information in order to educate the doctors, I think is not such a good thing.
Thank you, Frank, and thank you, Jody. This certainly is not the last word. With the Supreme Court ready to rule, we'll check back on this issue and find out who won, who lost, and what the implications are. Next up for Pharma Faceoff, has pharma given up on R&D? If you have any questions or comments, log on to pharmafaceoff.com.